Our next guest, speaking on the NSA, the Fourth Amendment, an amazing lady, an incredible speaker, Ms. KrisAnne Hall.
Well, you are going to have to forgive me because I have the one thing that every national speaker hates. I have laryngitis. But I am really going to be tethered to this podium, am I not? I mean, because this is just not me.
You know how to take the mic off.
Yeah, which one? There's two.
The one in front, that one. You move around with it.
Because I do not stand still well. So the fight still has to go on, right? The show goes on, the fight goes on. We can't stop fighting to preserve our liberties simply because of whatever the excuse may be. And when you're devoting life, fortune, and sacred honor to something, you don't let little things like laryngitis get into your way. So what I'm doing is I've got my laryngitis homemade remedy, because I don't believe in injecting chemicals into my body, nor into my child's, but that's not what I'm here to talk about. We're here to talk about the Fourth Amendment. And let's hope my little thing works. Oh, come on. Push the little USB thing in. Is it lit? There should be a little light when it talks to me. Wasting time. Don't you love technology? Because this is what it's all about, right? Is there a light on the USB?
No.
The light, okay, well it's not. The little bitty one, just take it off. Oh, are we gonna stay there and do it for me? Okay. All right. I'm sorry. I gotta figure out where I am now. Okay, I'm a constitutional attorney. I was a prosecutor for over 7 years. Worked in the criminal justice field for over a decade. So I am well versed in all of these exceptions to the Fourth Amendment. And I say that in quotations if I can. So I want to go over with you. Oh, listen, you lost the screen. There we go. Okay, so I want to go over with you some of the things that you're going to hear. And you're hearing these things in the media. And then I'm going to show you how they're completely extra-constitutional and unconstitutional. And so what you're going to hear are these court revisions of constitutional principles. They're going to tell you that there are exceptions to the Fourth Amendment. You're going to hear things like plain view, search subsequent to arrest, exigent circumstances, emergency situations, and then my overwhelming favorite, national security. But what we need to understand is what does the Fourth Amendment really say? So we'll go through this Fourth Amendment together. The right of the people to be secure in their persons, houses, papers, and effects. Now, if you can come up with something that you can possess or own or think of that doesn't fit in one of those categories, let me know, because I can't. Our framers were very clear that this is supposed to include everything against unreasonable searches and seizures. Now, what you need to understand is you are not protected from every search and seizure, just unreasonable ones. Now, what our judges and lawyers like to do is say, okay, well, but what is unreasonable? Because that's what we have to debate. What is unreasonable? But the problem is the Fourth Amendment tells us very clearly the difference between a reasonable and unreasonable search. You simply have to look at the language of the amendment in of itself. Now, our lawyers and judges don't know how to do this because our lawyers and judges are not taught the Constitution in law school. They're taught constitutional law, which is completely different. Constitutional law professors teach our lawyers, who will become our justices and our Supreme Court justices, that men and women in black robes know more about the Constitution than the men who wrote it. And therefore, since we are so much more intelligent today than they were back then, we can recreate and redefine principles based on our opinions instead of facts, history, and the principles of liberty. So here's what we've got. We've got, maybe I can use this thing anyway. Oh, no, I'm looking for my laser pointer thing. Laser. Okay, so we are only protected against unreasonable searches and seizures. So what is a reasonable search and seizure? A reasonable search and seizure, which a reasonable search and seizure is one where there is a warrant. One where it is based upon probable cause. One where it's supported by an oath or affirmation. One where it particularly describes the place to be searched and the persons or things to be seized. Now, when you're reading legal documents, it's really not as hard as your local attorney wants you to think, because then you won't pay him $250 an hour. So I want to teach you something here. Some of the most important words in the legal world are the little bitty ones. Like this one right here. What is this one? And. What that tells me as an attorney is that in order to have a reasonable search and seizure, it is a 5-prong requirement. Not 3 out of 5, not 4 out of 5, but you have to have all 5 before you have a reasonable search and seizure. So there must be a warrant for every search and seizure. That warrant must be based on probable cause, subject to due process review for every person searched. So they can't issue a general warrant and say, we have the right to search and seize the people of America based on this national security problem, because that's a violation, because according to the Fourth Amendment, every person has the right to have a due process challenge of their warrant, particularly describing the place to be searched and the persons or things to be seized. These are very, very clear words and very, very clear requirements. And that "and" thing says you got to have all 5, or it's unreasonable, and then you are being violated. We also hear about our governmental revision. Government and progressive educational systems wanting to rewrite history in order to justify an overgrowing, out-of-bounds government. Now, this was actually the opening to Barack Obama's address on the National Security Agency that he just gave on Friday. And I'm going to tell you what. I saw this. I was sitting in the airport, Kansas City International Airport, and I erupted into belly-hurting laughter in the middle of the airport when I saw this. Because I thought to myself, how can a speechwriter do that with a straight face? How? Because this is such a gross distortion of reality. And then you guys are going to hear from Charlotte Iserbit later. She's a hero of mine. She's going to tell you that we have been deliberately dumbed down for way too long. And I realize that the progressive education system that we have been indoctrinated in for generations is going to allow us to believe this. So at the dawn of our republic, a small secret surveillance committee born out of the Sons of Liberty was established in Boston. And the group's members included Paul Revere. And at night, they would patrol the streets, reporting any signs that the British were preparing raids against America's early patriots. Throughout American history, intelligence has helped secure our country and our freedoms. Are you stinking kidding me? Okay, so point number 1. Revolutionary War was not fought between the Americans and the British. There were no Americans in the Revolutionary War. They were British colonists fighting against their own government. This was not a foreign war. This was a civil war. Point number 2. The Sons of Liberty were not a governmental agency. The Sons of Liberty were the citizens who were fighting against the government intruding upon their liberty. They were you and me who are outraged by the fact that we have this national security exception that allows the government to say, well, you really don't need to worry about that Fourth Amendment because it doesn't apply to us in this situation. My question is, if the Fourth Amendment doesn't apply to the federal government, then why in heaven's name do we even write it? These are the things that we've got to understand. If we are going to be the truth bearers, because that's what we need. All right, go ahead and go to the next slide. The battle against government intrusion began for us, at least locally. Because I travel around the country, I teach the history of our Constitution, and I bring you, how many of you have heard the genealogy that I teach? Okay, so you guys know we go back to 1041, we go back to Edward the Confessor, and I trace the history of our Constitution all the way to the Declaration of Independence. But I just want to stay time-wise local now. And so for us, the history of this battle against government intrusion began in 1761 with a man named James Otis Jr. Now here's the interesting thing about this, because this is the truth, and what Obama said is just totally fiction. James Otis Jr. was a government attorney. One of the highest posts any colonist could achieve in the government, James Otis Jr. carried it. He was in charge of enforcing these writs of assistance and prosecuting people for the crimes based on the searches and seizures. Now, what were these writs of assistance? Writs of assistance were warrantless searches perpetrated on the colonists to search and seize their property, to enforce the unconstitutional taxations created by the British government. See, we didn't invent this Fourth Amendment thing, we inherited it. Our framers came here with a well-established protection of their privacy and their property. And the government was totally violating that with these writs of assistance. So what these writs of assistance did was give individual governmental agents the power to determine who to search and what to seize. Open warrants. Knock on your door and say, okay, my name is Agent so-and-so and Colonist Smith, by the authority vested in me by the British government, you will allow me into your home now. They had no authority to refuse, legally. And then these agents could literally go into the people's homes through personal motivations and take whatever they wanted and do whatever they wanted with it and arrest people at a whim. And because these were open warrants, the colonists had no way to challenge them legally. But James Otis Jr., a government attorney, began to realize just how tyrannical these writs of assistance were. So he was approached by some of the colonists, and he decided to resign his post for the government and blow the cover on this tyrannical law. So technically, James Otis Jr. was a whistleblower. He argued in the courtroom against the government for 5 solid hours against these writs of assistance. He called them the worst instruments of arbitrary power, the most destructive of English liberty and the fundamental principles of law that ever was found in an English law book. And they're no different than what the NSA and the federal government and the Department of Justice is doing to you now. Because you see, those who do not know their history are doomed to repeat its mistakes. So warrants based upon probable cause. These are the problems that James Otis Jr. had with these warrants. Bare suspicion without oath is sufficient, he said. Well, that's what Patriot Act says. Section 215 in the Patriot Act says we can overthrow the Fourth Amendment's requirement for probable cause and base every search and seizure on mere relevance. I'll remind you that Otis called this the worst instruments of arbitrary power, the most destructive of English liberty, and the fundamental principles of law that ever was found in an English law book. Warrants upon oath or affirmation. That means that every warrant that is issued is based on a single place or a single person, and every warrant must be reviewed by a judge, meaning every single officer must stand before the judge and swear to the veracity of that warrant. They actually do that. I have made warrants as a prosecutor. And there is always a clause. There is always a clause that says, I do hereby swear and affirm that the testimony contained in this warrant is true to the best of my knowledge. Am I right, officers? You see, your police officer cannot go to a judge and say, I want to get a warrant for everyone in my county so that I can search everyone in my county. But that's what these writs of assistance were doing. It is a power that places the liberty of every man in the hands of every officer. And that's exactly what these NSA warrants do too. You see, they go before the Foreign Intelligence Surveillance Courts and obtain a warrant that applies to everyone in secret. So you can't know you're being searched. You can't know that your stuff is being seized. And it's totally open-ended, which means every government officer who has this warrant has open authority to come into your home or take your electronic information, and they don't have to answer to anybody else. Otis said, what a scene does this open? Every man prompted by revenge, ill humor, or wantonness to inspect the inside of his neighbor's house may get a writ of assistance. Others will ask it from self-defense. One arbitrary exertion will provoke another until society be involved in tumult and in blood. The funny thing is our framers took this a whole lot more seriously than we do. But the truth of the matter is, the Government Accountability Office did an audit on national security letters, these writs of assistance in our modern day, and found out that in 1 year, 49,000 national security letters were issued. Now remember, we're doing this to keep us safe from terrorists, right? The Government Accountability Office figured out that of those 49,000 national security letters issued, 60% were issued on U.S. citizens and legal resident aliens. That means, according to the government, our greatest terrorist threat comes from you and me. And they're based on mere relevance, and they're absolutely open-ended. Any agent can use them, and there is no way you can fight them. Because although these writs of assistance that Otis dealt with, there was a gag order by the sword. You do not dare stand up against an agent at your door. These national security letters, how they're seizing all your stuff, contain a gag order. So if you're served with one, you can't tell anybody or you will be federally prosecuted. There's also an arm of these national security letters called suspicious activity reports. That allows the federal government to go in and seize your bank records. In that same government accountability report, they found out that there were 200,000 national security letters issued in 1 year, seizing over 2 million bank records. With numbers like that, you might know somebody who's had their bank records seized, and they will never know it because the bank cannot tell you, because there's a gag order that will federally prosecute your bank for letting you know that the government's been in your records. Not only that, before Janet Napolitano fled office, she issued a report that said these same suspicious activity reports allowed the government to go into your safety deposit boxes and seize anything that they find merely relevant or suspicious. And the bank can't tell you that they've been there, and they can't tell you it's gone because there's a gag order. Particularly describing the places to be searched and the things to be seized. James Otis Jr., in his legal argument, said, "A man's house is his castle, and whilst he is quiet and he is as well guarded as a prince in his castle, this writ, if it should be declared legal, would totally annihilate this privilege." Do you understand that these national security letters, this search and seizure by your federal government, takes away your liberty and your security in your home? It really, literally makes you the possessor and owner of nothing. What it means is the government owes everything that you own, and you merely possess it temporarily with their permission. He said, "Custom house officers may enter our houses when they please. We are commanded to permit their entry. Their menial servants may enter, may break locks, bars, and everything in their way. And whether they break through malice or revenge, no man, no court can inquire." Do you see this history repeating itself? But you know what alarms me more than that? We now have generations of people who will never ever know anything but government control and intrusion. Raising up generations of people who believe that it's a matter of national security for the government to own and possess everything that you own and possess based on their desires and their relevance. This is why this education is so important. Go ahead. The purpose of the Constitution. We've got to get back to some basics. The purpose of the Constitution is not to create the federal government. The purpose of the Constitution was to preserve liberty. Read the preamble. Preserve the blessings. It gives you a whole list of things that we're going to do. Why? To preserve the blessings of liberty to ourselves and our posterity. Not the creation of the federal government, but to preserve liberty. But we've somehow allowed our history to be rewritten and our education to convince us that liberty can be traded for security. Through the Constitution, we created a union of the states. You see, the Constitution is a contract that was agreed to voluntarily by the states. Not forced, but voluntarily. A binding contract that they agreed to, and in that contract they created and defined a limited federal government. So now I'm going to ask you a question. Go ahead. A federal government not limited and defined by the people. A federal government whose only limitation is its own will is not a constitutional republic. It's a totalitarian kingdom. And so when you have the federal government that can look you in the eye through the court system or through its agency, saying, well, that Fourth Amendment really doesn't apply to us. It really doesn't mean what you think it means. It means what we think it means. What you've got is a government that can define its own limitations, which means the only limitation the federal government has is its own will. And now you have a government who is not deriving its just powers from the consent of the governed, but a government who derives its powers from its own will, and that is a kingdom. Now, this is not a right-left thing. This is a liberty-tyranny thing. This is a good and evil thing. Because our conservative Republican House is just as guilty, if not more, for destroying our liberties in the Constitution. It was our conservative Republicans that gave us the Patriot Act. It's our conservative Republicans in the House that, by their own admission, will continue a program under a president that they hate. There was a town hall meeting in which Michelle Bachmann, Justin Amash, tried to eliminate the ability of the NSA to get into our stuff. A simple, direct, and pointed amendment that would have removed their ability to take your stuff without a warrant. Michelle Bachmann stood before a town hall and said, I am vehemently opposed to Justin Amash's amendment because your emails and your cell phone conversations don't belong to you. She said they're business records of the cell phone companies and the email providers. And since they don't belong to you and they're business records, then we can seize them under an exception to the Fourth Amendment, the business record exception. Justin Amash stood up and just blurted out, well, if we live in a country where my emails and my cell phone conversations don't belong to me, we're worse off than we think we are. I want to say, yeah, Justin, we're way worse off than you think we are, because our property, our persons, our houses, our papers and effects already don't belong to us. These laws, the Patriot Act, NDAA, all of these things make our possessions ours only through the permission of the government. And they can just take them as they please through mere relevance or suspicion. What kind of government do you want? A republic or this? So here are your solutions. Because I'm not just out here to be angry. I don't believe that all we need to do is be angry. I believe that we need to act. And we need to act as individuals and stop looking to the federal government to fix itself. Have you figured out the federal government is not going to fix itself? Yeah. Let me give you this now. And you know what? Changing out who is up there is not going to fix it either. Our federal government is like a car we've been driving in. And we just realized we're broke down on the side of the road. We haven't been going anywhere for a very, very long time. So we hop out the car, we pop the hood, and we figure out all the hoses have been slashed and the wires have been pulled out. And all this time we've been figuring we could get the car to drive again by simply changing out the drivers. It's time for us to elect mechanics. People who are proficient in constitutional principles, not those things that they learn in law school, but the things that the framers of this country knew through experience and wrote reams about. Jefferson said that the several states who formed the Constitution, being sovereign and independent, have the unquestionable right to judge of its infractions, and that a nullification by those sovereignties of all unauthorized acts done under the color of that instrument is the rightful remedy. Your states are sovereign and independent entities. Go read the Declaration of Independence in the last paragraph. It'll prove it to you. We started off as sovereign, free, and independent countries with the same power as Germany, France, and Spain, and Great Britain. Creating the Union did not change that. The 10th Amendment preserved that. So what we have to do here is understand that not only do the states have to nullify, but we have to do this on an individual basis through your counties, through your municipalities, and you as an individual as well. Now, I'm going to prepare you to defeat these arguments against nullification. Because when your state stands up and says, we are not going to allow these NSA searches to our citizens, we are not going to permit NDAA to be enforced here, these are the things that you're going to hear. It's not in the Constitution. The Supreme Court said no, and the Supremacy Clause prohibits it. So, it's not in the Constitution, but James Madison and Samuel Adams knew it to be right. Because it is in the 9th Amendment. The 9th Amendment reads, the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Your 9th Amendment is the most important clause in the entire Constitution. Your 9th Amendment is what makes us a republic and not a kingdom. The 9th Amendment declares that every right in the universe belongs to you. It's not given to you by the government. It is yours inherently. Sam Adams gives us some further information about this, understanding of this. Among the natural rights of the colonists are these. First, a right to life. Secondly, to liberty. Thirdly, to property, together with the right to support and defend them in the best manner they can. 4, life, liberty, property, and defense of those things. Nullification is in the Constitution. Why? Because it is your inalienable right to defend your life, liberty, and your property. These NSA seizures, these NDAA intrusions, the Department of Justice through its white paper telling you they can assassinate anyone they want, anytime they want, and the courts can't say anything, are all direct attacks on your life, your liberty, and your property, and you have an inherent right to protect those from anyone, foreign or domestic. They'll say SCOTUS, that's Supreme Court of the United States. That's our little lingo abbreviation we use for the Supreme Court. SCOTUS is the final say. Next slide. Jefferson says, oh look, my picture fell off. That's not supposed to be like that. Success, Jefferson had on his mind when he was talking about this. The idea that the general government is the exclusive judge of the extent of the powers delegated to it stopped nothing short of despotism. Since the discretion of those who administer the government, your NSA, FBI, DHS agents, since the discretion of those who administer the government and not the Constitution would be the measure of their powers. Madison, I love this, Madison gives you just a right punch in the nose to the Supreme Court. He says, if the decisions of the judiciary be raised above the authorities of the sovereign parties to the Constitution. Who are the sovereign parties to the Constitution? The states. So if the decisions of the judiciary be raised above the states, dangerous powers not delegated may not only be usurped and executed by other departments, but that the judicial department also may exercise or sanction dangerous powers. So we don't even allow the Supreme Court to even do with these things. We just do foreign intelligence surveillance courts, which are even outside the entire due process system. He says, consequently, that the ultimate right of the parties to the Constitution, who are the states, to judge whether the compact has been dangerously violated, must extend to violations by one delegated authority as well as by another, by the judiciary as well as by the executive and the legislative. Because you see, some people are going to say, well, nullification, you can't do that because the Supreme Court said so. But if the Supreme Court can judge and determine what the limitations of its own power is, and what the limitations of the other branch's power may be, then the Constitution no longer rules the federal government. It's the federal government who rules itself. Some will say the Supremacy Clause prohibits it, which I love this argument, because I don't believe that we can I don't believe in calling people names. I think the minute you start yelling at people and calling them names, you prove that you're ignorant and you have no argument. So, I don't call people names. I believe they classify themselves. And when somebody says to me the Supremacy Clause says nullification is not allowed, they show me just how illiterate they are, because the Supremacy Clause is very, very easy to read. See, Hamilton said in Federalist 78, no legislative act, therefore, contrary to the Constitution can be valid. Now, we live in a society where we like to redefine the meaning of the word is, but the last time I checked, that's a very clear and concise sentence, and no still means no. But Hamilton says if we deny this, if we allow legislative acts contrary to the Constitution to be valid, what we're doing is allowing the deputy to be greater than the principal, the servant above his master, and the representatives of the people superior to the people themselves. And then they'll say I have the power to do this because I said so. The Supremacy Clause is also very clear to read. This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land. That is not an unlimited declaration that everything that Congress does is the supreme law of the land. This is a qualifying sentence. So the Constitution is clearly, by itself, the supreme law of the land. But the laws made in Congress are only the supreme law of the land if they are made in pursuance to the Constitution, which is simply a reiteration of what Hamilton said. No legislative act, therefore, contrary to the Constitution can be valid. Our founders did not accept this tyrannical intrusion upon their inherent rights. This is what Otis said in his legal argument. I will to my dying day oppose with all the powers and faculties God has given me, and all the instruments of slavery on one hand and villainy on the other, as this writ of assistance is. These national security letters, these NDAAs, all of these things are exactly the same thing, and in their day, they were willing to fight. And we should not accept them either. My favorite founding mother said this: we will stand against tyranny today, or our children will bow tomorrow. Because you see, the young people are the real sufferers of our ignorance and our compliance and complacency. Because they're the ones that are going to have to fight. We have an obligation to them. Sam Adams said, if we tamely suffer a lawless attack on liberty, we encourage it and involve others in our doom. You see, when we go along with these because we've got nothing to hide, or it really doesn't affect me, or whatever your excuse may be, Sam Adams is saying you're being a cheerleader to tyranny. And you know what that means? He says it's a serious consequence. Because that means millions and ages and millions yet unborn will be the miserable sharers of our negligence. And Winston Churchill said, still, if you will not fight for the right when you can easily win without bloodshed, if you will not fight when the victory is sure and not too costly, you may have to fight with all the odds against you and only a precarious chance of survival. And he said there may even be a worse case. You may have to fight when there is no hope, because it's better to perish than to live as a slave. So I want to charge you today. We're either independent or we're not. We're either free or we're not. We're either in charge or we're not. And our children are worth taking a stand for, or they're not. This is your charge to no longer sit by as our liberties are whittled away and our children are sold into slavery, because they will choose to either stand with their blood or live their lives on their knees. And I don't want to be responsible for that. So let me tell you, I've got a booth out there where my ministry, my goal is to teach the truth. I have books out there, I have children's books out there. I have flyers, you can learn more about what I do. Last year I taught 265 meetings in 22 states. And I don't charge a dime for anything that I do. I speak because this is my life, my fortune, and my sacred honor. We support the speaking engagements through the sale of the books and through donations of other people. I'm not telling you that to pat myself on the back. I'm telling you that because if you have a group that needs to hear the truth, you've got no excuses. All you gotta do is call me and I'll come. Because it's worth it. And my child is worth it. And I'm willing to take a stand.